Hi everybody, Armine Bazikyan here, licensed attorney based in Los Angeles, California. I'm a certified specialist in estate planning, trust, and probate administration. This time in this video, we wanted to talk to you about how to create a will, a last will and testament. Now, there are two ways in California to do this. Before we get started, I want to preface this by saying that in California, a will is not the best way to transfer assets to loved ones. And we have lots and lots of information and lots of videos on this topic, so go and check out some of our other videos. We'll link it in this video about why it's not good to transfer assets using a will in California. But if you must, we're here. We're going to tell you how to do it. So again, as I mentioned, there's two ways of transferring or two ways of writing a will in California. The first is a typewritten or a typed out will, which we're not going to discuss in this video. The second way is a much easier way of doing a will kind of DIY at home. And so this video is going to be about creating a holographic will. And it's called a holographic will in the probate code section. And a holographic will basically just refers to a handwritten document that is your last wishes, that the court will respect, they will honor, and they will follow the instructions in. So let's write a holographic will, and let's talk about the different components that it must have in order for it to be considered an actual holographic will. So these are absolute requirements. If you're missing any of these, the court's not going to consider it a holographic will, so be very, very careful. The first very important thing for this document to be considered a holographic will, and by the way, I'm writing it on a whiteboard. It's going to be on paper when you write it, but realistically, it doesn't have to be on any particular type of paper. It can be literally on a napkin, and the court will respect your wishes. So it just needs to be handwritten. That's the first requirement, is that it's written by hand. If you type it up and sign it, it's not valid. If you type up half of it and write half of it, it's not valid. It has to all be written in your own hand, because the court is going to look to verification of your handwriting to make sure that it is yours. And that's one of the ways that they're going to actually not make sure that there are other requirements that are not met. For example, in a typewritten will, you need two witnesses. In a handwritten will, you don't need the witnesses because presumably it's with your own hand and they can verify your handwriting to make sure that it is yours, right? So in a holographic will, we don't need the two witnesses. So let's get started. So in a holographic will, the first thing we need is for it to be handwritten. The second very important component is that it is, it talks about your intent. There's a statement of your intent. So this might be very simple. I might just write my will, and that might be the title to my document. This tells the court that this is my last will, that I intend for these provisions to talk about my last wishes. I could be a little bit more fancier, and I can write like, this is my last will and testament. Okay, so generally speaking, there needs to be some sort of statement about my intent for this document to be my will. The second most important, or the third most important component in this scenario, is that my signature is on there. So my name, I've written my name down, but also I've signed my signature to this document. The next very important part of this document is that it be dated, right? So you have to put the date that you wrote this document, and it could be either in numeric form, it could be written out, it doesn't matter, you just need the actual date. Don't write just the month and the year, or the month and the day. Write out the full legal date, okay? So we need date, we need your signature, we need your statement of your intent, and we need to make sure it's in your handwriting. In this middle section, you could put whatever you want about your stuff. So you could do a general statement about all of your stuff going to a group of people in certain percentages. You can do specific line items of, my car goes to this person, my house goes to this person, my bank accounts go to this person. It just depends on what you want. So in this case, I'm just gonna put all of my stuff. Try to be, use plain English. You don't have to use like fancy, what you would think legalese would look like. You could just say something like, all of my stuff to be given, I don't know, to my kids equally. Also try to write in a good penmanship, have good penmanship, because this is going to be read in court. So you want to make sure that the judge can actually read your handwriting. Don't be messy like me. Because then it's going to just create confusion and ambiguity. So all of my stuff goes to my kids equally. That's where I want all of my things to go. And then also I'm going to have kind of a general statement about, you know, my, I don't know, husband to be in charge, to be the executor of my estate. I'm telling the court, you know, I would really like my husband to be the one that submits this to you in court and administers this estate. So those are very important. Now, we've done a video in the past about the things that you should include in a will. So if I have minor children, for example, I absolutely also want to include information about guardianship nominations. So check out that video. We'll also link it down below. But for the most part, this is a general, what we call a holographic will, which basically just means handwritten. It's with my own hand. They'll verify my signature, they'll verify my handwriting, and these are my wishes. And then it'll be a valid will and you're all set to go. So be very cautious when you do this. I don't recommend you do this. I do recommend you consult with an attorney because in California, it's very expensive to probate a will. It's always better to do it through a trust, and that's why we have trusts in California. But if you must, this is one of the ways of writing your own will at home. Of course, as an attorney, I have to say that I don't recommend that. I recommend that you consult with an attorney first before you go off and DIY it yourself sitting in your living room. There are certain things to watch out for. Again, we'll link some videos down below about the things not to include in your will and the things to include in your will. So be very cautious about creating inconsistencies in this document. Make sure what you're writing is very clear and it doesn't create confusion. The more confusion you create in this document, the more expensive that court case is going to be, because a judge is going to want explanation after explanation after explanation. And the longer it's in probate, the longer it's going to take and the more costly it's going to be for your family members. So we hope that you found this very helpful. If you have suggestions or questions about other topics, feel free to comment down below and we'd be happy to film some videos answering those questions. Otherwise, if you'd like to consult with our office, we do provide free consultations for residents of California. Again, we're licensed in California, so if you're a resident of California and you'd like to seek out our help, we'd be happy to provide you with a free consultation. Call our office and we'll schedule you with a consult and maybe help guide you through this process. Have a good one.